don't really understand. So a lot of people don't really understand what has been happening to us since, the Act of 1871, followed by the Act of 1917, making us all enemies of the state, and then the Act of 1933 that took away all of our property and assets. We don't know about all that. We think that we have got our constitutional rights when they've declared that we are enemies of the state until we prove otherwise, which is what we've gone into with KL. Because he's doing the DOS process, the Declaration of Status, which is not a sovereign citizen thing that they've created this negative image about, but it's declaring that you're not an enemy of the state, you're changing your political status. So Ron here is knowledgeable of all this stuff too, and part of it. But I wanted to start this out with last week, we had a hearing with Ken and Brad here. And I was there, Nelson was there, a few others, and we were witnessing what this judge was, his demeanor. That's why I went there, to see what they were doing at the JP level. And just like all these other judges, they go to, if they're lawyers like this guy was especially, they go to law school and they get indoctrinated, I guess, for lack of a better term, to be self-righteous and arrogant and putting themselves above you, especially when they become a judge. They are dictators. They've assumed that role because most people that go before them don't really understand what is happening to them until it's already happened. And so what I'm going to do is just kind of go over that briefly, because I was talking to Ken about that a minute ago, where my observation was that as soon as that hearing started, that judge started chastising them and belittling them and boosting his own ego with his grandiose history of being a pilot in the military, and then he went to law school, and I'm your overlord. You've got to obey everything I say, no matter if it's legal or not, or lawful. So anyway, I had a hard time keeping my mouth shut, but I'm just in the audience like the rest of us were. But he did dominate them and belittle them, and he was arguing on behalf of the other party, and they hadn't even spoken yet. And he's building the case against Ken and Darren here. So they have a lot of opportunity to fix that, but also I think we all need to learn the basics of when they start doing this, how to put them in their place properly. And, I used to be a little bit more forceful and demanding whenever one of these public servants would violate my rights. I'd put them in their place pretty quick and pretty authoritatively. I've learned to be a little bit more calm about that, and I'm trying to stay in equity, because if you have to remove it, you want to say, hey, higher judge, federal judge, whatever, this is what happened. And this guy was being unreasonable. He was arguing on their behalf, blah, 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 blah. So what I would do in that situation, as I was telling Kenny, is when this judge started arguing on behalf of the other side before hearing anybody speak and belittling them for not being educated and using legal words they might not understand and blah, 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 I would have said, Your Honor, is your intent to deprive me of my right to due process? Well, no, you have rights. Okay. Then why are you arguing on their behalf when they haven't even spoken a word yet? You are not here to be a litigator. You are here to let us litigate this case, and you are supposed to abide by the rule of law and rule accordingly. So it appears that you have violated my rights already, and you already have your mind made up on who's winning this case, and nobody's even spoken yet. So do I need to get a copy of your oath of office and your bond? When you say those two things, they're going to go, no, you can proceed. Thank you. I'd like to call the witnesses now, and you're not one of them. So then you proceed on asking the witnesses in your sequence of things, and that leads into what Ron and I are going to talk about here, because that case was about Ken and his Jeep, where it was wrongfully repossessed in the repossession entity bank, they didn't follow the procedures of law. They didn't file the notices, blah, blah, blah. Okay, they violated the law. Not Ken. And I asked Ken if he had done a debt validation first. He told me he hadn't, but that was afterthought. Well, that's what Ron is doing, is he's telling us, look, be proactive, go and file this stuff before they ever get any idea that you're going to challenge them. So as you're current on your payments, doesn't matter if you're going to be late or whatever, you file these debt validation letters that Client has perfected, and they have all the language in them. You just apply it to your situation. And so like the first one, and I'll let Ron go into it some more, but the first one is saying, I offer to pay you in full. I'm just kind of paraphrasing. It says, I'm going to challenge the debt validation, and I'm going to challenge you to provide me the records, because we know they don't have them. They don't exist. When you signed on that dotted line, if you did, then they scan it into a digital version and they shred the paper version. It no longer exists because they don't want to pay for the storage and security of those documents. Well, this was a funny thing because this is common amongst all of these bankers now. When Ken and Darren had the bank representative on the stand, and he was a lawyer too, which you should have objected to that, but yeah. Okay. Anyway, so he got up there and admitted a few things voluntarily, but when they asked for the wet ink signature document, which they had requested before, he says, well, we don't have that. We don't provide the certificate of title or the original contract. Those are in a secure vault location. Okay, for what? Why are they in this secured vault? For maybe a day in court where you prove that you do have the debt, there is a valid contract? If we're in court, where is it? If they don't have it, there is no loan. There is no loan anyway. We all know that because they never created a loan. They never loaned you a dime. They created money out of thin air by your promissory note. Well, then when Ken and Darren here talk about, well, we have a promissory note, the judge says, oh no, that's an agreement, an installment agreement. That's not a promissory note. When I sign my name on that dotted line and it is for financing, you're saying, I promise to pay in the future. That's a promissory note. So the judge, first of all, lied in court. He's not under oath, but he lied. So he's being deceptive and he's omitting the truth, violations of the law, and he's defending the other side without speaking yet. Okay, so Ron backed that up on the fact that you sign on a dotted line if it is a supposed repayment kind of future, it's a promissory note. And what happens then, and these guys kind of referenced it, they said, well, what about securitization? Well, they didn't have background yet. That's kind of why we're doing all this, to give you guys all this background on how you proceed in this sequence. And that is that when you go into the securitization, you just get the banker out there and you say, okay, look, did I sign a loan? Yes. Where's the document? In a secured location. Is it here in court? It's in a secured location. Did you bring it with you? Is it in your folder? It's in a secured location. Your Honor, I move for immediate dismissal or a summary judgment because they didn't bring any proof that there is a debt. We demanded it. It's in documentation where we demanded it. This would be a miscarriage of justice if we went any further. Judge is going to say, well, no, they have an opportunity. Blah, 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 say whatever they're going to say. Okay, you got it on record. that you demanded that. Okay, so when they go past that, and they say, well, you signed this thing, where is it? Well, you can photocopy it. Photocopy is inadmissible unless I approve it in consent. I haven't done that. I have challenged you on the debt and score with the loan program and asked for all these other documents that are required by law upon the challenge of the debt. You didn't respond in any way. It's been past 30 days. Therefore, when you took the vehicle after that first 30 days, then you violated the federal law, UCC code on debt collection because you didn't provide the evidence. After 30 days, if you don't provide it, you can't do anything. You can't call me. You can't text me. You can't email me. You can't come and see me. You can't do jack. Yes. Until you come here with the documents and prove that debt. That's it. You're dead in the water. That's how it's supposed to work. But the judges are in cahoots with them because they're lawyers. And it's all part of the British Accreditation's registry, the bar. And they pay dues. It's a country club. It's not a legal process. It's a foreign entity, and most of them don't sign the foreign agent documents. So you can challenge them on that. The judge is going to like that because he's 1-0, right? So you're not going to win anything, you're convincing him that these people, these attorneys are foreign agents and they're not allowed to be here. It's just a good old boys club, and that's the way that it works. So that's an argument for later on in higher court, like a federal equity course. So
what they've done is made you totally intimidated. We've got to stand up anyway.
Right. You got to learn how to stand your ground, and to do that, you need to learn the background on how to proceed and what they're doing and what you anticipate they're doing based on the history of them in general. So by anticipating that, you can have a list prepared for this court. And you can go down that list with, if they say yes, then there's this flow chart item. Go to that sheet. If they say no, go to that sheet. And go down the rest of your list on how to confront them. It doesn't really even matter if they think that you're making good points or not. What matters is that you're getting that on the record. So when you go to appeal it or remove it to a higher court, it's on the record. They can't deny it. And if they try to shut you up, which they've tried to do to me in the past, and that didn't turn out well for them. I had some attorneys in a case that tried to intimidate me into answering either yes or no. I said, no, thank you. I'll give my answers. Well, that's a yes or no question. Maybe to you. I want my answers. Well, then you get up here and answer them. When I did that, that judge came out of his seat, was screaming at me. I didn't give a shit. Because they are our servants, and they need to be reminded of that. But all that's on the record. Guess what? I'm going to have some fun with that here in the near future. Yep. So anyway, but I'm just trying to get at is they will try to intimidate you into compliance. That's what they all do. Even though it's a violation of law, it's a violation of the judicial canons. They cannot be rude to you. They cannot be defamatory to you. They cannot slander you. None of those things. They have to remain in equity. But they never do anymore. They used to. Every once in a while you can find a judge that does, but most of them don't. They want to intimidate you into compliance and finding you the guilty party, even if you're the plaintiff who is following the law and it's going to make them follow the law. So then it goes into the question sequence of securitization. Okay, that judge knew that day when these guys mentioned securitization, he knew what they were talking about. Yet Darren here actually misspoke and said, what did you say? It was
the body was bad, and I could scrutinize.
Scrutinize.
I couldn't see it.
Yeah. So then the judge says, "I think what you mean is securitization." Well, that just is the key right there. He knows what's really going on, and he's trying to head you off from getting to the point of asking those questions. So you got to plan for that and be prepared to ask the sequence of questions that lead into that. And then when you confront them and say, well, did you bring your documents on the securitization? They did admit on their own that it was securitized. Bam, right there, they've lost. Anybody here know why?
You're no longer the holder of each corner.
That's part of it. What's the other part? That's what Ron and I are going to talk about today. When they go into securitization, they have separated the contract from the promissory note.
They don't.
There is no contract anymore.
Yeah.
There is no debt anymore. And when the investor buys it from the original contract issuer, you don't have a contract with them. You're happy for them to sell it. And in your agreement, it says, you agree to let us assign it to somebody else. Sure. Somebody wants to come in and pay my bills, have at it. I'm happy. And it's done. I don't owe you anything anymore. Thank you very much. But the judge won't let you get there unless you do it strategically. So then you start asking them about their securitization process. And well, Mr. Witness, when you securitize something, does that not separate any promise to pay for and separate that from the contract? Okay, here's these laws then. When he says yes or no, it doesn't matter. So well, here's these laws and case laws from the Supreme Court and many others that say when you separate those things, there is no debt. Here they are. Are you going to override the Supreme Court? Are you going to take that judicial authority upon you right now and claim that it doesn't apply to you? I would like to see you try that, because then you're committing a fraud upon the court. So then you could go into the whole breakdown of the securitization process. Well, who is the holder of due course, like she said? They don't have anybody there representing the holder of due course. They are no longer that, so they're committing a fraud upon the court by being there. They don't have standing. That's the whole thing about securitization, is they waive standing. So when the bank sells it to, well, it's real estate. It's called a REMIC. Okay, so they sell it to a trustee of another group. They pay your debt off, and then they take that. And the best example I've heard is what happens in a securitization. Okay. When they take the contract and promissory note, sell it, they have separated those two things and they paid it off. Okay? When they separate them, they then put it in the REMIC, say for real estate. If it's any other asset, it's an ABS and it's all through a special purpose vehicle, which is a SPV. Okay? Once they do that, they have destroyed the original document, the promise. They've destroyed it. Two other things on that. When that promissory note is paid off, that bank then, through quantitative easing, they then replicate that as an asset up to 30 times. So they loan up to 30 times to other people the value of that face of that promissory note, because that is money. It's the only money we have. We don't have gold and silver anymore, which Ron will explain to you. When they change that, they then split it up into a million pieces. And as I started saying, the best example I've heard of that is, say you have carrot, and your neighbor has a carrot, and everybody down the block has their own carrot, and all of you take out a loan on that carrot, and the bank then takes those carrots as equity or whatever, assets, and then they turn them into juice. So now it's carrot juice. That's the separation of the promissory note, the carrot, making it into another financial instrument, the REMIC or ABS or whatever securitized item that is. It's destroyed and made into something else. You never agreed to that other legal document. You didn't sign on it. They didn't notify you, and they're going to go off and sell it to on the market like stocks. And all these other investors are going to buy those shares. Well, who is the holder in due course? There is none. Did I just answer for you?
Yeah. I can tell you, one of the best ways to either shut that down or make them produce is to, it's real simple. All you have to do is say, I'm happy to accept your copy as equivalent to the original, which is what they're trying to force you to, right? As soon as you relieve me of the liability of any like similar copy coming in. And if you're holding 10 of those in your hand, they're going to know that you're smart enough to collect against whoever has to accept the liability. I'm happy to search those 10 documents on you and put you in the same hole you're just trying to put me in.
And I like that argument. Ron will tell you here that his debt validation letters that you preemptively file against them do all of that. So what you're doing is saying, look, in his debt validation letters, you're saying, look, I'm challenging your debt because I don't think you have the documents. So you supply me with all these documents that are required by law. And when you do that, if you prove that we do have a valid debt, I will pay you in full.
So
There is no case in controversy. You're offering to pay in full. You're not saying I'm not going to pay you. That would be a controversy. I'm saying you prove the debt, I can help you to pay it. Guess what? They never do. Because they don't have the documents. They shredded them. Okay? So, anyway, I better shut up and let Ron talk, because he's the expert. I'm just kind of giving you the overview. Okay, Ron, chime in there,
Hey,
buddy.
how are you doing? Can everybody hear me okay?
Yeah.
Yeah.
Am I speaking loud enough?
Yes, I'm trying to bring it up too.
Good day to all you Texans down there in Tejas. Remember the Alamo.
And go ahead.
Anyway, I was really impressed that you opened up the meeting with prayer, because when there are more than two of us in a meeting, 3, 4, the Lord is with us. Anyway, I just want to remind everybody what the good Lord bequeathed to us in his last will and testament, which is the New Testament of the Holy Bible. He gave us 3 gifts, as any grantor would give their beneficiaries. He gave us dominion over the world, and that's evidenced by the book of Genesis, chapter 1, verse 26, when God said, let us make man in our image, after our likeness, and then let them have dominion over the fish in the sea, over the fowl in the air, and over the cattle, and over all the earth, and over every creeping thing that creepeth upon the earth. So God created man in his own image. In the image of God created he him. Male and female created he them. And God blessed them. So we have dominion over the world. Not corporations, not courts, not governments. Men and women do. The second gift he gave us is he made us sovereigns without subjects. This was in his last will and testament, the Holy Bible. And that's evidenced by Genesis 1, chapter 27. So God created mankind in his own image, male and female. He created them. In chapter 3, verse 22, and the Lord God said, behold, the man is become one of us, to know good and evil. And now lest he put forth his hand and take also of the tree of life and eat, he will live forever. So he made us gods. And lastly, he made us beneficiaries of our life estates. Think about the laws of trusts, grantor, trustee, and beneficiary. In chapter 1, verse 29, then God said, I give you every seed-bearing plant on the face of the whole earth, and every tree that has fruit and seed in it. They will be your food. And to all the beasts of the earth, and the birds of the sky, and all the creatures that move along the ground, everything that has breath and life in it, I give every green plant for food. And it was so. So he gave us dominion over the world. He made us kings and queens without subjects. And he made us beneficiaries of our life estate. That's who we are. That's our status. That's our status. when we go into court, when you're going into the courts in the U.S. here, they're owned and operated by the British Royal Crown Bank Corporation, and they're administered by the judges and the bar attorneys. They're the boots on the ground for the British Royal Crown Bank Corporation. And whenever you go into court, you're going into an admiralty or maritime court. You're not going into a common law court. So our remedy to get us into a common law court is to say these words when they call your name. I reserve all my rights under Uniform Commercial Code, Article 1, Section 308, without prejudice. That automatically puts us into a common law venue, not a maritime or an admiralty venue. So we're stepping off the sea, we're stepping off the pirate ship, and we're stepping onto the land. We stand on the land once we say that. In the Uniform Commercial Code, that's the law of merchants and bankers. And since 1938, all courts have been run under the contract law of merchants and bankers. Our one safety hatch or safety valve is Uniform Commercial Code, Article 1, Section 308, without prejudice. And that puts us in common law. Now, once we say those words, we can demand, not ask, we can demand from the trustee who's prancing around in a robe, calling himself a judge or a magistrate, but he's a public servant and he works for us. We're the sovereigns, he's the public servant, the way it should be. Now, we can ask the public servant, Your Honor, is this a civil matter or a criminal matter? And if he says it's a civil matter, that means we can now ask for the international contract that we're obligated to perform under. What is the international contract that we're obligated to perform under? And I'll give you a hint. The whole purpose of the court system, owned by the British Royal Crown Bank Corporation, is to get repaid the national debt. $39 trillion or whatever it is today. That's their only purpose. So whenever you go into a court in America today, you're the taxpayer and they're the tax collector, and they're going to fleece you. Like my Scottish grandfather used to tell me when he put me on his lap. He was a union activist that came out of Scotland in 1914. He got blackballed out of the shipbuilding union because of his union activities. And Samuel Gompers sponsored him to come into New York. He was the head of the AFL-CIO, and they formed the Steamfitters and Boilermakers Union in New York City. He worked many years in the Brooklyn Navy shipyards, and he was a welder. But he told me, he said, Sonny, me boy, never go into court unless you want to be fleeced like a sheep. And I'd say, Grandpa, what are you talking about? You know, Perry Mason, the courts, they're fair. And he just grinned at me and laughed, and he says, you'll find out. But remember these words. Don't go into court unless you want to be fleeced like a sheep. So when you go in there and you reserve your rights under Uniform Commercial Code, Article 1, Section 308, without prejudice, now you can demand to see the international contract you're obligated to perform under. That's the national debt. So you can tell the magistrate or the public servant or the trustee, whatever you want to call them, put into evidence now the national debt. Because this is what it's all about. I want to see the national debt. Of course, he won't do it. He'll try to shut you up because he'll admit, if he does that, he'll admit that the U.S. government is bankrupt and they're now shaking shekels out of us Americans to pay the national debt, which isn't really a national debt. It's paper money that's been printed out of thin air that they're charging the government interest on. It's fake monopoly money. There's no national debt, doesn't exist. It's just a pretext to collect tax. So once they cannot produce the international contract you're obligated to perform under, you immediately move to dismiss the case with prejudice because there's no debt. They didn't produce it. And then walk out the door. That takes care of that civil matter. Any questions on that before I go to criminal?
That's good.
Hello?
I think we're okay, Ron.
Okay. No questions? I'll move on to criminal. So if the judge says, no, this is not a civil matter, this is a criminal matter. Now that you've reserved your rights, you're entitled to face your witnesses. The people that have either done two things. They've sustained bodily injury on their person or property damage on their property. If you haven't done any of those two crimes, there's no crime. If there's no witness in the courtroom that has sustained bodily injury or property damage because of your action, you immediately, say, are there any witnesses with a claim against me in the court? And if you don't hear anything, Your Honor, I move to dismiss this case with prejudice. There's no aggrieved party. There's no damaged party. End of the story. Get up and walk out the courtroom. You're done.
Yeah. Yes.
Any questions on that approach? Either civil or criminal matter.
Wow.
That's pretty cool,
Now,
isn't it?
Very cool. Very cool. Love it.
On what they're going to say is that the state is the injured party, against the peace and dignity of the state. And that's what they will say.
What do they say?
I'll say the injured party is the state, for example, the state of Texas, because
The injured party is the state?
dignity of the state.
That's impossible. The state is nothing but a figment of the imagination. It's ink and paper, nothing more. It's not a living, breathing soul or spirit. It's not. How can it sustain an injury?
That's what they say.
And I've had them say that to me too. But then I say, well, your officer here that's taken the stand that gave me the citation, it claims on the paperwork, he's just a witness. A witness.
Well, the way you respond to that is a citation. I'm standing on the land. I'm in common law. Your codes, regulations, and statutes do not apply to me, and I don't consent to be under its jurisdiction. Those merely apply to court officials, policy enforcers, namely police, and government workers. I'm none of those. I reserved all my rights on the Uniform Commercial Code, Article 1, Section 308, without prejudice. I want to see the injured party here. I want to see the party that sustained property damage. If he's not in the courtroom, court dismissed.
And that's why I said that's the corpus delicti. And I've argued corpus delicti in a few traffic cases, and the judges just about come out of their seat when you say those words.
Let them come out of their seat. They're demons to begin with. They fly. If you think I'm wrong, challenge me now.
You are right. You are right.
No, I'm wrong. So here's another approach. Which I've used. I've been sued like 7 or 8 times since 2015. Several credit card debts, a commercial loan with a Citizens Bank NA. And I haven't paid anybody, no lawyer, no bank, no gangbangster, a thin dime since then. Not even a wooden nickel. I went in pro se to those court proceedings, and I prevailed. I have this channel on Telegram. It's called the Ronald Adams Room. And I've posted all the judgments for the defendant there with all the docket histories, as proof of the pudding. I've worked with a family out in Missouri, and in bankruptcy, we got their house free and clear out of a foreclosure proceeding. The other thing I do is called forensic property and mortgage loan audit reports. It's about a 60-page document that looks at things like, is the plaintiff legitimate or is it fake? Is it a placeholder on a complaint? 95% of the time, it's fake. It's a figment of the prosecuting lawyer's imagination. It's the lawyer who's coming after your property, wants to steal your home, the equity in your home, or to fleece you. It's the lawyer. It's not the entity you see on the complaint. I've gotten several complaints dismissed because if you look at the face of the complaint, whose signature is on the complaint? It's the lawyer, not the officer of the corporation that's theoretically the plaintiff. It's always the lawyer. Guess what? That complaint is not verified nor validated, so it's void. You demand from the magistrate, present the validated, verified complaint. This is signed by the lawyer. And to tell you the truth, Your Honor, I don't think the lawyer has a plaintiff client. He hasn't, I've asked him with my debt validation letters to present his contract and retainer agreement with the plaintiff, redacted where necessary. He hasn't done it. You know why? Because he doesn't have a contract with the alleged plaintiff. He's coming here under his own authority, waltzing around the courtroom, making bold-ass accusations about me and how I owe money, and it's all a lie. If he's let him prove his worth. Let's have him present to the court his retainer agreement and his contract that he has a plaintiff. And I want to see that contract to make sure an officer of the corporation that he says is his plaintiff has authorization and power to sign contracts and to hire lawyers approved by his board of directors. If he can't produce that, this authority should be thrown out of the courtroom. He has no authority to be here. Secondarily, he hasn't got a certificate under 22 USC section 611, 22 USC versus 611, that he's complied with the Foreign Agents Registration Act. He's a foreign agent. He has to register as a foreign agent to do business in America. How is it he has the authority to utilize the court machinery when he can't provide his certificate that he is duly registered? Your Honor, throw this man out. I've had those discussions too. And there was a lot of stuttering and stammering on the part of the attorney in court. Once you understand you're the sovereign and they're the public servants and the trustees, you have a different attitude. You have a different attitude.
Can I ask a question?
Yeah, go ahead.
So, what if the fine has already gone to collections?
In other words, is it a credit card or a court fine? What is it?
Speeding ticket citation.
Okay, so the court didn't collect it, right?
Correct.
And the court sent it to collection?
Yes. And I think
beautiful.
I think the collection agency, it seems to me by their address, I think they're like in the cubicle next door.
Okay. If they forwarded your account to a collection agency,
mm-hmm.
You're sitting like a Cheshire cat in the catbird seat. You know why? Do you have a contract with this collection agency?
No.
So why are you obligated to do anything for these people?
Mm-hmm.
The answer is you're not. So you want to send that collection agency a debt validation letter saying, I'll gladly pay you, but prove that I have a contract with you signed by both parties.
Mm-hmm. Okay.
Show it to me, the original, and I don't want a copy. And I'll know if it's not a copy because I only sign contracts in purple ink as a sign of royalty. If you send me a copy, a photocopied counterfeit copy of a contract, and it's got a black signature? It's not mine.
Mm-hmm.
I had a lawyer trying to cross-examine me in a credit card case, and he's showing the court a copy of a credit application that I signed. And the judge says, "Did you sign that, Mr. Adams?" I said, "Let me look at it." He showed it to me. It was a photocopy, a counterfeit copy. It's the same thing as you and I photocopying a $100 bill and trying to negotiate it. I said, "No, Your Honor, I never signed this document. That is not my signature on that document." Well, he says, "Is it similar to your signature?" I says, "No. I only sign contracts in purple ink. This thing is black. And I can tell you right out straight, looking you in the eye, that's not my signature."
Okay, now I signed the citation without prejudice under the Uniform Code. The citation.
Okay, so you reserved your rights without prejudice.
I did.
All right, so the way to do that in the future is you sign it by your name, all rights reserved under Uniform Commercial Code, Article 1, Section 308, without prejudice.
That's what I did.
All rights reserved under Uniform Commercial Code, Article 1, Section 308, without prejudice.
Mm-hmm.
And that means, and you should probably put under there signed under duress, right?
Yes.
Because if you didn't sign it, they'd probably try to arrest you or something,
Right.
or impound your car.
Right.
Yeah. So you say signed under duress after you write that all rights reserved under Uniform Commercial Code, Article 1, Section 308, without prejudice. And then when you go into court to appear, you reserve your rights again right at the beginning of the court, and then demand to see then ask the magistrate, is it civil or criminal?
Mm-hmm.
And if he says, well, it's civil, then demand to see the international contract you're obligated to perform under. And then say, if you can't produce the international contract that I'm obligated to perform under, I move this case be dismissed with prejudice. That puts him right in the box. So he's either got to present the international contract for your strict examination and inspection, or he's got to dismiss the case. You've given him two choices.
Mm-hmm. Great. Thank you.
Any other
So,
questions so far?
Ron, I wanted to add another point that KL makes. If you've gone through KL's process for the DOS, that if you sign it with your 3-letter initials, comma, agent, then it is automatically recognized in the higher courts anyway as being under trust law. And the trust law preserves all those rights. So you can do it that way as well. And that way the higher courts know that it is a trust issue and only federal courts have jurisdiction over trust law.
Yeah, I want to give you an example. I was taking my wife to the beauty parlor for her monthly beauty treatment. And when I left her, I picked up my phone and looked at it. And there was a cop across the street in a cruiser, and he observed me picking up the phone. In Massachusetts, you can't have an electronic device in your hand while you're driving. So, the blue light comes on, he pulls me over, and he says, license and registration. I said, "Are we on the record, officer?" He says, "Yes, we are." I said, "I reserve all my rights under Uniform Commercial Code, Article 1, Section 308, without prejudice." And I said, "You know what that means, correct?" He says, "Give me your license and registration." So I gave my license and registration. He comes back and he says, "Mr. Adams, I'm going to give you a warning this time. You're not supposed to have a phone in your hand while you're driving." I said, "Great, officer. Make it a great day." And that was it. He didn't give me a ticket because he knew what was coming down the pike. Another time I was in court, the court clerk or whoever who was calling the names said, is Ronald Adams in the courtroom? It was a credit card case. And I said, "Your Honor," are you calling the live flesh and blood man, or are you calling the trust? Just to tweak him a little bit. And she says, I'm calling the name. I'm calling the name. Now, I took it to mean, I said, I understand you calling the name is really the name of the trust. Is that correct? And she was silent. Now, what is silence in a courtroom? It's acquiescence, right? It's agreement. If they're silent, that means they're agreeing with you. Now, here's another way to, you understand that all court procedures and all court cases are really construed trusts. They're construed trusts, or some people call them constructive trusts. Now, with the trust, there are three principles. You have the grantor, the one who places the asset or the res into the trust, or the thing of value. You have the trustee, who is either the court clerk or the magistrate or the judge, and you are the beneficiary. Now, when you go into this court, and see each role, each principal has a different role. The grantor puts the asset of value into the trust, and it's for the benefit of his beneficiaries. The trustee is the one who's managing the assets in the trust, protecting the principal, and paying all fines, fees, and penalties of the trust. The beneficiary is only entitled to the benefits of the trust. Can't touch the principal, but gets the dividend and interest income that the principal generates, the asset generates. Okay? And that's the relationship. So when you go into court and they ask you for your name, the judge at that point, or the magistrate, is the trustee. He's responsible for all the fines, fees, penalties, and expenses. So he's on the hot seat. Now, when he calls your name and you give it to him, you've contracted with him, and now you're the trustee, and the state or the judge is the beneficiary, or the court is the beneficiary. So you've got to be very careful about that interplay there, so you don't contract with them and become the trustee, because they're going to find you guilty, and you're going to be responsible for all the fines, fees, and penalties because you've been hoodwinked. They've switched roles with you, and now you're the trustee. So you always have to remain as the beneficiary. Now, the way to do that is when you go into court, before you get started, and you reserve your rights, you say, magistrate or judge, I just want to get something clear here. I want to know who everybody is in the court and what their role is. And then I'll point to the prosecutor. Is the prosecutor, you're the grantor of the trust, is that correct? There might be silence. Silence means agreement and tacit approval. And you, Your Honor, you're the trustee, is that correct? Same thing. Or the clerk. I'm the beneficiary. So you declare, you express verbally, you made an expression and a declaration to everybody that you're the beneficiary. You're only responsible for the receiving benefits of the trust. So by assigning the judge and the clerk as trustees, they're responsible for the fines, fees, and penalties and expenses of the case, and to settle and close the account. So when you go in there, you have to set the playing rules. You have to turn the tables on the money changes that are in the court, because the court is a bank. It's like when Jesus went into the temple. What did he do? He tipped over the money tables, and he changed the rules of the game. You know, he cast the money changes out of the temple. Same thing in court. You have to take charge and, take over the direction of the court. Any questions at this point?
Yeah, Ron, Nelson here wanted to ask if you would revisit who was the prosecutor in that play? Okay, he's asking who was the prosecutor in that description that you just made?
All right, it's the attorney bringing the complaint. Okay, if it's a civil matter, the attorney who filed the complaint is the grantor of the trust. You know, because when he brings that complaint into court, he's bringing potentially a document of value. That's the res. That's the asset that's going to give the trust value. You've heard the term res and value. Well, that complaint has a value. You know, the court case is a money-making operation for the court. Okay, because they potentially are going to get an account receivable from the fines, fees, and penalties related to the case, the charges, or the complaint, whatever it's worth.
That's why when you go to court and you get a copy of the docket, it will have in there the bonds that they've taken out because they're going after the bonds. They're going to collect on you, whether you pay out of your pocket or not. They're going to collect on the bonds. That's
So
the
what
whole
they
racket.
do is they sell all these cases to an underwriter on Wall Street because they have value. You know, there's going to be money coming out of the case, your fines, fees, and penalties, and they sell those ahead of time, and they probably sell them at 60 cents on a dollar. And then they're bundled together in terms of asset-backed securities, collateralized debt obligations, etc. And they're sold on Wall Street in trusts. And those trusts have units, and they sell those units to the investing public, insurance companies, life insurance companies, investment companies like Vanguard and Fidelity, you know, municipal bond funds. That's where those asset-backed securities come from.
Oh, Ron, go into that a little bit more about the securitization process, what it does. Like, you know, I did my opening, how it separates the two and becomes something else, and then who the sequence of holders in due course are, which they can never prove in court when they try to foreclose on you or confiscate your assets or whatever. Would you go into that?
Yeah, sure. When you go, let's take a mortgage, for example. When you go through a mortgage process, and I sent an email to Ken, a couple of them before this thing got started, and if Ken can maybe forward it on to all the participants here. There's one called when you buy a home, how does the transaction work? It's about a 2 or 3 page document, but it gives a pretty good description of the debits and the credits and all the accounting that goes into a mortgage loan. But essentially, you started the process by filling out a credit application with the bank or the financial institution. And you put your signature and your social security number on that document. And you indicated how much money you wanted to, how much credit you wanted to borrow. Now, the person or the financial institution that received that instrument, it's a negotiable instrument at that point because it's got a date, a fixed sum, it's got a payee, the financial institution, you're the payor. As payor, you put your signature on it and your social security number. And your social security number gives the financial institution a key to access your credit in the U.S. Treasury. That social security number is like a key. And once you give him your signature and your key, you've given him permission to access your credit at the U.S. Treasury. Okay? So if they approve your credit application, they will forward the credit amount, it's credit, these are accounting entries, to the financial institution. So if it's a 30-year amortization mortgage that you've applied for, it's not only the principal of, let's say, $250,000 you're taking out for a potential home loan, but it's also the interest that you would pay over 30 years. So it's probably 4 times the amount of the borrowing amount. So that financial institution then gets that credit and credits your account on their books and records. That's a liability to you. Okay? That's a liability to you because it's your personal information. So when they call you up 3 days later and say, "Oh, we got great news. You're going to get your house. Your credit application has been approved." They've already got the credit from the U.S. Treasury. Okay? Now they want you to come in and sign some papers. Usually a mortgage agreement to turn over title to the home that you're going to buy to the financial institution, and a promissory note, which is a negotiable instrument. So when you sign those documents at a closing meeting, and there's a closing agent there, usually an associate vice president for the bank or the financial institution, and you and your wife or your partner come in, you're signing these papers, and you're signing your initials on every page. You're getting all excited because you can see the house, you can taste it. You're going to pick up your wife and carry her across the threshold, getting all excited, and she's saying, "Honey, you got to get a house for me, You're the best thing. You're the best thing since Superman." So now the agent gets those papers signed and he's running out the door. Right? Did he give you a receipt for the promissory note? Did anyone ever get a receipt from that closing agent for the promissory note and the mortgage agreement that you and your wife signed and gave to him?
Nope.
When you go to a bank and you got your paycheck and you deposit it with the clerk of the bank, and they give you back a what?
Receipt.
A receipt, a deposit slip, right? And that's proof that the bank has a liability to you, does it not? And you can go home and get your checkbook out and write checks to the amount of that deposit slip, can you not? Well, it's the same thing with a negotiable instrument called the promissory note. Under Uniform Commercial Code, Article 3, Section 104, called negotiable instruments, it's the same kind of instrument. You deserve a receipt. You should never let that lawyer run out of the room without giving you a receipt, because you've given him an instrument with your signature that had $250,000 written on it. That's like you depositing a check for $250,000 and the bank didn't give you a receipt. Right? So in other words, my point is, when you gave him that promissory note, he should have given you a receipt, proof that you deposited with his financial institution. It was an exchange. If you look up the word exchange under Black's Law Dictionary, it's exchange of equal assets, similar assets. Ink and paper, called a promissory note, in return for a bank check for $250,000 to go buy your home. There was no debt. There was no loan. It was an even exchange. Now, when that bank took your promissory note, they recorded a debit to note receivable on the asset side of their books, and they credited an account called depositor's liability or borrower's liability. That's the amount they owe you for the amount of that promissory note. But they never tell you about that entry. You think the bank gave you the money out of their vault. They did not. You created the money with that by putting your signature on that instrument. So when they deposited that promissory note, their capital went up by $250,000. So when they give you a bank check to go buy your house, they haven't lost anything. They're not short. There's not $250,000 missing from their vault. You created the money or the credit with your instrument. You follow me on that?
So Ron, that's why in your debt validation letters, you have the request for their general ledger in there, because both of those accounts, left and right side of the ledger, should show an increase rather than one being decreased and the other increased, right?
Right. So you have 250,000 on the bank's books and records. There's an asset that increased 250,000 for your promissory note. And on the liability side, the negative side, there should be a $250,000 corresponding negative entry or a credit. The debit's on the asset side, the credit's on the liability side, and the same amount of money. So the bank's capital hasn't changed because you created the money with your instrument. So whenever you go into court on a credit card, bank lending loan, or a promissory note in a foreclosure, never admit that there was a debt or a loan. Never do that. I mean, if the judge turns to you and says, well, Mr. Adams, you borrowed the money, didn't you? The answer is, Your Honor, what are you talking about? What money are you talking about? Well, you got the house, didn't you? That's what they usually say. You got the house, didn't you? And I exchanged a promissory note for that same amount to the bank. They're whole. They haven't lost any money. They're not damaged. They're not aggrieved. I exchanged. You got to look that word up. Exchange in Black's Law Dictionary. And you'll see it's an even trade. Quid pro quo.
And
A and
that's,
B equal.
that's why they,
Ink and paper for ink and paper. Never admit to a loan. When you go into court, never, ever admit there was a loan or a debt. Don't do that.
so Ron, can you hear me?
Yeah.
Okay. So that's why they will never respond to your debt validation letter, because they will not produce that general ledger that does that, that shows that, because that would prove that they had committed fraud, bank fraud, and then fraud on you, and now fraud upon the court if you go to court. And so that's why they just ignore all of the debt validation, in addition to the fact that they don't have the documents anymore. But that was the exact issue with Darren and Ken last week in court. That judge even asked them if they had not paid their payments. And then he goes into this thing talking about how if you go into an agreement and you don't come through with your payments, then you're in violation of your agreement and you are evil. That is just pure evil, is what he said.
Made it a moral issue.
He made it a moral issue, yeah. And based on the deception that has been going on for
And I would have
decades.
said, Your Honor, are you an advocate for the plaintiff here? Because you're clearly prejudiced against me and biased towards the plaintiff. Are you not impartial? If you are not impartial, you want to step down off the bench and we'll get somebody else.
And that's what we've gone through this morning a few times. So, anyway,
Your
okay, so
Honor, your job is to look at the evidence and make a decision. Your job is not to be an advocate for the plaintiff. Correct me if I'm wrong.
okay, so Ron, can you go into the whole securitization process and what it does to the documents? And one of the points that this judge made with them last week was that, oh, that's not a promissory note, that's a agreement for, what do you call it? Retail agreement.
Retail sales agreement.
Retail sales agreement. And I told these guys, I said, look, when you put your name on the signature of that, it is a promissory note, period. Would you agree?
When you put your signature on that retail installment agreement, was there a signature of the opposing party, an officer of that corporation on that agreement too?
No, and they did argue that too. And the judge says, well, they don't have to sign the documents because they acted in constructional agreement, because they moved forward and so did you with making payments.
Your Honor, Are you familiar with UCC Article 2, Section 201, called the Statute of Frauds? Let me remind you that
Can you repeat that?
Uniform Commercial Code, Article 2, Section 201, the Statute of Frauds. That's the law, the state law that deals with contracts. And there have to be two signatures on that contract for both parties who are authorized by the respective boards or parties to contract on their behalf.
And they have to provide their authorization documents from the board to appear
Yeah,
in
they
court.
have to have a board approval, usually in some kind of minutes to a board meeting, saying that they're authorized to enter into contracts on behalf of the company.
That ever happened?
Nelson is
So
asking
you have to correct the magistrate or the judge and remind them about the statute of frauds.
Do the
And
board, does
if
the,
he doesn't abide by that, that's an appealable item.
hang on, Nelson's asking a question.
does it ever happen that a board of directors does in fact authorize an
Yes.
attorney to do that?
I can answer that, yes. I've encountered one, but and this one was several years ago. I found those documents online through their website, and this person who was testifying for them was approved at one point, but it was long after this action. So he was committing a fraud, yes, but they do that.
And my other comment would be to remind you that at that case, Penn was told by their defense was the Texas Civil Code regarding the retail installment contract. They referred to the Texas code, not to the UCC.
Correct.
That's why
Well,
they
you
were allowed.
remind them about Uniform Commercial Code, Article 2, Section 201, which I believe under Texas law is a state law for commerce and banking.
It is.
You know, they may have some other like Texas Commerce Law, Chapter 2, 201 dash
A or B or something like that.
yeah, Article 2, Section 201.
Yeah, so they are comparable to the federal level. That most states have duplicated, but just given it their own code. And a lot of times it's the same code, just under state jurisdiction.
It'll be on the Secretary of State's website.
Okay, she's saying that it would be on the Secretary of State's website. Okay, so Ron, can you go into the part about the securitization and how it destroys the...
Okay. So typically these brokerage firms, these financial institutions will sell your financial instruments to a Wall Street underwriter. These underwriters will take that, they'll pay money for that instrument. So that proves that your instrument had value because a Wall Street underwriter will pay a discounted amount of money for that instrument to the broker. All right. So if let's say the value of the instrument had $250,000 face value, and they sold it for $220,000 to a Wall Street underwriter. The Wall Street underwriter then has what's called a real estate mortgage investment conduit trust vehicle, a special purpose vehicle. It's called a real estate mortgage investment conduit trust, a REMIC. You've heard the term REMIC. And they'll populate that trust with thousands of those kinds of agreements, so that there may be $2 or $3 billion in financial instruments in that trust. So you look at this trust as kind of like a kettle of fish swimming around in the kettle. That trust has valuable assets in it. So let's say there's $2 billion of assets in that kettle of fish. Well, what they'll do is they'll sell $10 billion of units, of trust units, to the investing public. So look at the trust as kind of a company, and they're selling stock or shares or trust units to the investing public, namely life insurance companies, pension plans, investment companies like Fidelity or Vanguard, and they'll sell the trust units. And the trust unit, they have a deal with the investor. Let's call them the investors, that they'll pay 5% return every year if they feel like it. It's not guaranteed, only if they feel like it. So the manager, the investment manager of the insurance company says, well, 5-6% might be a good return because I'm only getting 1% from the bank for cash sitting in the bank. So I'll take a risk and hopefully get my 5 or 6% return on those trust units. So that's how the securitization model works mechanically, if you will. Well, what they were finding out in 2008, when they went to look in the kettle of fish, there were no instruments in there. Wall Street sold units to the investing public on a kettle of fish that had no fish. That's when everything went south in 2008, because the scam was up. Now, as far as the securitization, those underwriters got insurance from companies like MBIA or American International Group, AIG, that guaranteed the payments from the mortgage, the borrowers. So in other words, if someone defaulted on their mortgage, the underwriter said, hey, we've got a promissory note and a mortgage agreement which are not performing. We're going to submit it, it's 90 days overdue. They've defaulted. We're submitting this as a claim to AIG. Well, in 2008, as more and more of these claims got submitted, AIG was going to go bankrupt. Remember Hank Greenberg from AIG? So that's when Hank Paulson and what's his name? Geithner. I forget his name. He was the Secretary of the Treasury. And Hank Paulson. Tim Geithner.
Timothy Geithner.
Yeah. They went to Congress and said, hey, we've got a problem here. The insurance companies are going belly up because they can't satisfy all these claims. You're going to have to print more money to make the underwriters whole, because AIG is going to go belly up. So they took over AIG. What?
And that goes into the quantitative easing.
Yeah, they took over AIG. They got Hank Greenberg out of there, and then Bernanke took over the administration of AIG. They pumped billions and trillions of dollars, I think $58 trillion into AIG in order to pay off the credit default swap contracts that the underwriters had on Wall Street. Goldman Sachs, Morgan Stanley, JP Morgan Chase, Citibank, everybody that was issuing these REMIC trusts. So that's what happened in 2008. And that's kind of essentially how the underwriters got AAA ratings for these investments, by getting credit default swap contracts which guaranteed payment if a borrower defaulted on their mortgage payments. Okay.
Okay, so Ron, now now that we're on that subject, I've seen this come up a couple of times, and last week was one of them with Ken and Darren here, where they asked if they tried to ask if the bank had been paid off by insurance, and that goes into the REMIC, because once you default on the REMIC or ABS, then on day 91, they automatically apply for the loss and write the debt off, they don't discharge it, they just write it off and take the tax credits, but they also claim the insurance, and so AIG pays off on those claims on the REMIC or ABS. And this judge was bulldozing over these guys last week and wouldn't let them go down that path. But
Oh,
he
yeah,
knew.
because you know why? Because he knew you were over the target. You were over the target.
He didn't answer the question. I asked the judge, do you allow them to get paid insurance and try to collect money out of Ken also? And he wouldn't answer the question.
Of course he wouldn't, because you were right over the target. You asked the right question. You know, he'd have to fess up to the Ponzi scheme they got going here.
Right. So basically, the judges know the game because they're part of it.
So
They're
the
fighting-
moral of that story, what's the fellow's name that just spoke here?
That's Darren.
Darren?
Brad.
Brad. So Brad, you were right over the target. So, you know, your next question would be, so Your Honor, by your silence, I'm taking that as tacit approval that you agree with me and that there's no injured party here. There's no aggrieved party. So there's nobody in this courtroom with a claim against me. Is that true?
And that's what their lawsuit was about. Was
So if
Ken
there's
was
no
the
injured party and nobody with a claim, there's no controversy or no dispute. This court has no jurisdiction because there's no controversy, there's no loan, and there's no dispute. What are you going to adjudicate here?
Ron. That they were actually arguing that because Ken was the plaintiff wanting the Jeep back and whatever money he had paid on that Jeep that they could not prove there was a loan for, and they had no documentation, whatever. But the judge, just like all these judges, just bulldozed his way over them and, you know, spoke the party line for the attorneys.
And we also asked the judge, would you sign, he said, I'm
An
going to
affidavit.
affidavit. We claimed that the negotiable instrument was something different. We were using UCC, and he did it according to what he said it was. And we asked him, would you please sign that? Just put it in writing so we can understand what you believe a negotiable instrument is. And he also ignored that too.
Yeah, he ignored it because you were right over the target and you had him cold. You had him dead cold. You know, he wasn't gonna perjure himself and say, "Oh, you know, it's nothing." He was just silent, right? He wanted to change the subject. That's when you got to reel him back in and say, "Well, from what I'm understanding going on here, Your Honor, there's no case here. There's no debt. There's no aggrieved party. There's no injured party. There's no controversy and therefore no dispute before the court. So let's adjourn here."
Well, that's what I was saying. Ken and Darren here were the plaintiffs. They were trying to hold the other side accountable. That's why there was a case in controversy, because the bank was claiming they were entitled, and they were suing because they had stolen the vehicle and didn't follow the law.
Right. Well, they've got a valid case there. They've got a valid case. Triple damages. They stole the car. That's triple damages.
What happened, Ron, was initially
I understand. Okay.
I went in with Ken as his counsel to help him with the case. And the bailiff said, you can't do that here. It's against the law. And I told him, according to Texas Penal Code 38.123, I can do any case I want to except for personal injury and property. But he didn't care. He said, I'll arrest you if you do this. So I said, Ken, just make me a plaintiff, a co-plaintiff, and I get in there and assist you with it. So their whole attitude was terrible from the very beginning when they saw me back in that room. And then I basically got in just being a participant. The bailiff hated my guts, basically, and the judge. So the first 30 seconds, we could tell what they're going to do to us. It was just,
Darren, correct me.
Yeah.
Were you guys plaintiff?
we were plaintiff. So it kind of made it where the judge had to kind of step back and think about it because we weren't the defendant. And it's probably very unusual for a plaintiff that someone claimed owed money was trying to get damages from them. But it was a very unusual case.
And let me add that I've told them that it probably would have been a better process to file a quiet title action against the vehicle, because then the bank could not produce the records and you win.
how do we make a judge not, like, when they just keep not wanting to do the right thing because of whatever reason, we can't make that, can we?
Yes.
Right on at
Oh,
that,
at the beginning of the hearing, you could say, Your Honor, we've got to take care of a little bit of old business here. Are you operating on your oath of office here today? And if he says, I am, can you present your oath and your indemnity bond for my inspection and examination? And that'll get his attention real fast. And then you
And that's
say, I accept your oath of office.
Yeah, you got to accept it so they are liable.
Yeah, you say,
So-
I'll accept your oath of office then.
Yeah, that's kind of what I said in my opening statements here is you ask them for their bond and say, well, do I need to ask for your bond and your oath of office? And that'll get their attention real quick. And then you could ask for it too, instead of just
And
saying,
you
do I
say,
need to?
I accept your oath of office. Please present it. In my hand for my strict examination and inspection.
we don't have it.
If they don't have it, then they are prostituting themselves. They're impersonating a official, a government official, when they are
I
not.
have it, but I don't have to show it to you.
That's what a bond is for. We demand that they show them. We, the people in the Constitution, demand that they have bonds. And if they don't have them, they are pretenders in the office. They're frauds.
They're an imposter trespassing on an official office.
Right. Criminal complaint against perjury or if
I guess, Bill,
okay.
Ron, from the very beginning, we asked the judge, we want the court reporter in the room so it'd be on the record. And he said, we don't do that here.
There's a JP court. They
Yeah.
are not required. You can bring your own.
Yeah, well, next time we'll bring our own. That was critical to have it recorded.
It's not a court of record unless you request it to be.
Okay.
I mean, that's a good way to get a continuance saying, you appear, Your Honor, is this a court of record? If he says, no, it is not, then I move we continue this case in the future when we have a court of record.
Or it gets removed to county court for that.
Yeah.
Can you request that for any court case?
Yeah. Yeah, you want a
Absolutely.
record. You know, they summoned you into court. They invited you into their house. So if you appear, you want a court of record so that the what is said in the court is documented and transcribed for your use.
You have to have a certified court reporter, or if you just hire someone to come in there and say, I'm the court reporter.
They got to be certified for you to be able to have the record admissible in a appellate court or higher court.
That's what I thought.
Yes. But it's up to you. You can hire one. Even if they've got one, you can hire your own. You don't have to pay them their contracted, employee basically to pay them a profit. You can bring in your own court reporter at whatever expense, or, hey, I'll trade you a cookie if you do this. Whatever you work, negotiate. That's between you.
You know, if you got a traffic ticket or whatever, and it's a civil matter or whatever, you can immediately file a motion to dismiss the case.
Why?
Or a challenged jurisdiction, which they'll never be able to
challenge jurisdiction. You can challenge the alleged debt. I mean, you just file a motion to dismiss the case, and there are several causes of action that you can put in there. See, I find in these litigations, it's better to be on the offensive instead of on the defensive when you're a sitting duck, kind of like a duck in a shooting gallery. 2 weeks ago, let's see, I'll give you a case I was involved with. I got a call like June 10th for this woman that was in foreclosure, and she was facing a July 2nd sheriff's auction. She calls me up and says, Mr. Adams, can you help me? I said, explain to me what's going on. And she had been in litigation for 15 years trying to save her house. She went through a bit of divorce, has 2 kids in their early 20s. She's the only one living living in the house, and house needs like $200,000 of renovations because she hasn't had any money to do the repairs and maintenance. Needs a new roof and all sorts of renovations. So I said, well, when's your next hearing? Well, we've got a hearing coming up June 25th, and they're going to auction the house off on July 2nd. I said, well, so I thought about it, and I don't usually come up with these ideas right off the top of my head. I have to sleep on it. And then around 3 a.m, voila, I get this bolt of lightning and I get an idea. So anyway, the next day I got this idea. All right, we'll file a quiet title action with a temporary restraining order and an injunction. So I've got a couple lawyers that I have on retainer in my business. They're retired litigators. So we put our heads together and we came up with this plan of action, put the paperwork together, a quiet title action with a temporary restraining order and an injunction. So we filed it into the court 3 days later. I think it was June 13th. And the motion for quiet title was heard June 25th on my anniversary. It was my 48th wedding anniversary. So we go into court, and the magistrate looks at the paperwork, and it was a masterpiece. I got to tell you, it was a masterpiece. And he says, well, looking at this paperwork, it's probably evident to me that she will prevail with this quiet title action. So I'm going to grant the restraining order and the temporary injunction. So the sheriff's sale got canceled on June 2nd, 2025, a couple weeks back. So this lady, 57 years old, proceeded to do cartwheels down the corridor. And this is a 57-year-old woman. Happy. And I figured, this is a crapshoot. She probably won't get it. But, I'm called in like, with less than 3 or 4 days to get a filing in, and then a week and a half before the hearing. But it worked. So she had a friend who was who was a friend from the same town, Milton, Massachusetts. And she had a friend that was also facing a sheriff's sale on the same day. So she calls me up the next day and says, Mr. Adams, can you help me, So her case was not as strong, but we ended up filing a Chapter 13 bankruptcy on June 2nd and got the docket number at 3:59 p.m. that afternoon, and she was facing a 5 p.m. sheriff's sale. So because we had the docket number for the Chapter 13 bankruptcy filing, it was able to stop the sheriff's sale. So she was happy too. But, she's in bankruptcy, and that's a whole nother road to hoe there. So with the first lady that we got the injunction approved or granted, we're now filing a motion to convert the temporary injunction to a permanent injunction, which means you'll get the house free and clear.
Oh, wow.
So we sent our paperwork off to the opposition about a week ago. They got 4 more days to respond. If they don't, the filing that I will do based on their non-response will be an automatic approval of the permanent injunction. You talk about a happy camper.
Okay, so Ron, I think we've gone through a lot of the debt validation process and what they can and can't do and what they have and what they don't have. So is there anything else that you'd like to add and maybe take questions from people?
I'd just like to say that this great monetary reset, have you ever heard of this before, the great monetary reset?
Yes.
Where Klaus Schwab says you'll own nothing, but you'll be happy?
Yes.
He wasn't kidding. There is a war that's been declared on the American people to steal their wealth by the British Royal Crown Bank Corporation, the corporations, the government, the banks, and the Bar Association, and the cities and towns. And they're going to do that with three ways. High interest rates on mortgages, which, the Federal Reserve refuses to drop the mortgage interest rates. Increase in real estate taxes in your local city or town.
Mhm.
Increase in property insurance premiums from the insurance companies. And increasing on the food. So the basic necessities of life, they're manipulating and increasing the price to put everybody into foreclosure.
Hmm.
They can come sweeping in to steal the equity in your home. This is the great monetary reset. This is what's really going on. These are demons looking to destroy America. And if you disagree with me, I want to hear your reasoning right now.
Anybody? Nobody here?
No takers?
No, I don't think so.
Tacit,
Okay,
your
so-
silence is tacit approval and agreement with me, right, guys, ladies, gentlemen? So the only way we can win is stick together.
Yep.
Stick together. Remember the Alamo, William Barrett Travis, James Bowie, Davy Crockett, Colonel Dickinson. Remember the Alamo, March 6th, 1936, I think it was, wasn't it?
So
18.
I ask you
30.
all about, I just got a notice, on a toll. They want like $1,700 from Illinois, which was 4 years ago or something. And, I haven't even looked at it. It came in about a week ago. How can I address that?
You send them a debt validation letter, a conditional acceptance. I'll pay you if you can show me the original contract between you and I,
Okay.
with wedding signatures by officers of your corporation and myself. And
So that-
counterfeit copies will not be applicable here.
Okay, so that's what I want to go in next.
You call it
Hang on. That's what I wanted to go into next with Ron, because Ron offers his services. He's got 3 packages that you can purchase from him to help him do this process. One is you get the documents and do it yourself. And the other is a higher level where you still get the documents and then you get coaching from Ron and, his hand holding, walking you through it. And the other one is where he does the whole thing for you. So Ron, you want to talk about that?
Yeah, which one is Ken? Ken Omet? Ken raise his hand?
Yeah, he did. He's back here in the corner hiding.
All right, so I sent Ken a couple of emails with all that information on it. If he could forward it to the folks, they can click on the website links on the emails and they can, review the website themselves. I don't know if you can forward it to the distribution list.
Yeah, Ron's asking if you could forward that to everybody in here that wants to have. Okay, so he said he'll send it to Darren and he'll forward it to everybody.
Yeah, I mean, if you want to go to the website, it's www.debtremediationtools, DEBT, the word remediation, REMEDIATION, tools, plural, .org /go, and it gives you the 3 options. But once Ken forwards the email, you can just click on the email link and it'll take you right there. And then there's one called www.debtremediationtools.org /register. Instead of go, it's register. No spaces. It's all, and there's a 2 or 3 minute video that takes you through it, that you see my ugly face there on the video.
And then you also offer to appear in court by Zoom calls or whatever as an expert forensic CPA, correct?
Yeah. I mean, my background is I'm a certified public accountant, but I'm also certified in financial forensics. I have a CFF designation for the American Institute of CPAs, which means I passed a rigorous test and submitted some reports for review. It's called CFF, Certified Financial Forensics. And I'm also accredited in business valuation and have several accreditations and certifications in business valuation. So I do a lot of expert witness testimony in court as an expert. So I testify in like marital dissolution cases where there's a family business involved and they need to value that business for the divorce settlement, or if there's shareholder disputes and there's a valuation issue, they want me to value the company to figure out what the shares are worth. And tax litigation I also do. So, I appear in court, I get sworn in as an expert, and I testify. And I also do foreclosure defense litigation and expert witness testimony. And I also perform forensic property and mortgage loan audit reports. Okay, which I sign an affidavit and attest to.
No question in my mind that you're an expert, but you've testified as an expert, but have you been certified as an expert by a court, and which court has certified you?
Yeah, most of the courts are in New York and New England, for the most part. Connecticut, Massachusetts, New Hampshire, New York, New Jersey, Pennsylvania. I've actually testified in Sarasota County down in Florida.
Mhm.
And I've never been disqualified as an expert. Once they see my credentials and my CV, I'm always accepted by the court.
Those are right behind you, aren't they, on the wall?
Yeah, I mean, I've got a few. I was very good. My mother was from Germany. She was a war bride during World War II, and she would never let me watch television as a kid. She always threw a book in my face. So as a result, I was very good at taking standardized tests. I'm a good test taker. So, I basically took that skill to the bank.
Ron, one of the things you said that they're trying to keep us in bondage is over the property taxes. Now in Texas, they have found that a lot of counties are just making up amounts. They're not, there's no forensic accounting to justify the property taxes. Do you get involved in that to either?
Yeah, absolutely. I prepare challenges to tax assessments in the cities and towns. And there's a company called Vision Appraisal, which most of the cities and towns in America have utilized for the revised assessments on real estate properties. Now, what I have found, being an appraisal expert, is that those assessments are not in compliance with, I'll say it very slowly, the uniform standards of professional appraisal practices. Uniform standards of professional appraisal practices, called USPAP. That's an acronym, USPAP. And I have submitted challenges to my own city and town here in Massachusetts, saying that the assessments are about 30% overvalued. 30% overvalued means that people are going to pay more real estate taxes each year. Okay? And their methodology is not in accordance with USPAP, the Uniform Standards of Professional Appraisal and Practice. And there was actually a guy in Texas who started this. I forget his name, but he appears on YouTube, and he's a developer.
I sent you that link. That was, I want to say Glenn something.
Becker or Beck or something like that.
Denton County.
Yeah, he started in Denton County, which is close to us here.
And I've actually taken his stuff, and now I'm working in Massachusetts, filing challenges to the assessments in Massachusetts. Several.
Well, he's also come up with a criminal complaint that you can file against the tax assessors for making these false statements.
Yeah, so I'm at the point now where I've sent them several correspondence in the mail. And the next step is to file a lawsuit against them.
Good.
Yeah.
Good.
Ron, I received, it was a short little TikTok about this gal who had bought an RV and a vehicle to pull the RV. They had put their money in from their bank, and somehow it tapped into their social security account and it was paid in full out of their social security. Is there a way to do that? A standard way to do that?
You mean the keys to the kingdom? You mean manna from heaven?
Yes.
I don't know. I
We
know
know,
what you're talking about, but I haven't seen anybody successfully do that.
well, we know it's coming, but a lot of us want to do it now. Of
Yeah,
course.
I'm not sure about that. I couldn't give you any advice or recommendation on it because if I haven't done it myself, I don't teach it.
Mm-hmm.
All the stuff I'm teaching is I've actually done it myself.
Mm-hmm. Okay. I just thought you were here. I thought I'd run it by you.
I mean, you can
I've got a-
discharge debt with financial instruments, like a certified promissory note.
Okay.
I've done that myself. I discharged my daughter's $75,000 college student loan, and I've discharged my own debt with Citizens Bank NA
Okay.
using a certified promissory note and 21 Susan B. Anthony dollar coins or a $21 U.S. Postal Service money order. And the reason you're using $21 is you can guarantee a trial by jury with a $20 fee under the Seventh Amendment of the U.S. Constitution.
Okay.
You should read the Seventh Amendment of the U.S. Constitution to understand that.
Thank you.
Yeah. Hey, Ron, I've got another question for you here. There's an individual that's written a book on land patents. His name is Ron Gibson. I was wondering if you have any experience with land patents, allodial title, or MCOs, Manufacturer Certificate of Origin.
Ron Gibson just
I've looked at that. I haven't really studied in depth. I'm the only guy I know that's read the Uniform Commercial Code front to back twice. I know lawyers haven't even read it once. They usually sleep through the UCC course in law school. Land patents, that's where you basically go back to the grants from the King, I think, of England back in the 1700s to trace titles back to the land. I think land patents deal strictly with the land, not necessarily the building on the land, I believe. And I've looked into it in Massachusetts, and Massachusetts will allow it if you give them 5 years of real estate taxes in advance. So if you're paying $10,000 a year in real estate taxes, it could be 50 grand they want you to pony up front,
Let me add to that. That's a statutory allodial title, which is manipulated just like the common law is. In Texas, we have that also, where they will grant it under certain circumstances. But you're still asking the government, our servants, for permission to do something. They created their own little version of it. But what you're talking about with Ron Gibson's project is to get back to the original organic allodial title, which we should have.
But then when they ask you to pay that $50,000 that he was just talking about, now it goes to another issue. With what?
Yeah.
My paying with.
Right.
Let our fellow choose with production.
So, Ron, why don't you just, for property taxes, just rhyme the promissory note?
Well, that is a strategy. Write out a check. If they give you a $10,000 bill at the beginning of the year, for the new fiscal year, write out a certified promissory note with a $21 U.S. Postal Service money order and discharge that sucker.
I like it.
It's interesting.
I have a couple questions. They're not related, I don't think. First is, you were heading down the road before regarding criminal cases, whether the case is civil or criminal. When I was in a misdemeanor court, I asked that question, is this civil or criminal? The answer was quasi-criminal. So how would one respond properly to that?
Your Honor, I do not understand. Please repeat that.
He would just say it's quasi-criminal.
Show me the law book, statutes, or codes where that's written. Because quasi-criminal is a new law venue which I'm not familiar with. And in order for me to properly defend myself, I need to study the book and how to do that. Please present me that guidebook for the quasi-criminal jurisdiction.
I can't swear to this, but I think I actually saw it in the statute somewhere of New Jersey. But on the next, and the second subject, which is not related, well, actually, back on this subject, how does one deal with criminal matters, say a felony or a misdemeanor, and would they be different? One being in a municipal statutory court, the other being in a county statutory court.
Well, you want to clearly reserve all your rights up front under Uniform Commercial Code, Article 1, Section 308, without prejudice. And if it's a criminal court, show me the injured party, show me the person that has sustained property damage. If you cannot bring the injured party who sustained bodily injury, nor the person that sustained property damage, I move this case be dismissed with prejudice.
Gotcha. And so I guess I just must not be asking the right questions, because it seems I get to the point where they just basically railroad over anything I've stated because they refuse to answer it and just move on. And my question is how to.
Oh, you just say, Your Honor, you haven't answered my question. I do not consent to move forward. I do not consent to move forward. Say it 3 times. I do not consent to move forward until this issue is resolved.
Okay.
One time I was in a credit card case, and the opposition attorney wanted to interrogate me. And, they were trying to railroad and bulldoze me. And the attorney, the magistrate says, well, the attorney's going to ask you some questions. I says, Your Honor, I haven't been subpoenaed to answer any questions today. And if I had been served a subpoena, I'd move to quash. I'm not testifying against myself. Oh, well, this is small claims court. We're loosey goosey with the rules here. I said, okay, let him ask his questions. Mr. Adams, did you get a tattoo for $750 and charge it to your credit card bill or credit card account? My answer was, I do not understand. What? I do not understand. And then he says, well, Mr. Adams, did you use your credit card to go buy some bubble gum or a sarsaparilla at the local drugstore? I don't understand. I do not understand. And the magistrate says, are you going to say I do not understand to all this attorney's questions? I says, absolutely. And that was the end of that. That was the end of that.
So do the judges ever surrender, or do they constantly find in the bar's favor? And
No,
then
in my cases, they I did ask the attorney a couple of questions. I said, Mr. Dixon, I said, do you have any firsthand knowledge of any of the facts in this case? He said, no, I do not. Your Honor, I rest my case. There's no witness in here with any firsthand knowledge of any of the facts of the case. They dismissed the case. They dismissed the case.
So, Ron, have you ever ended up in jail?
Me?
Yeah.
See, my name is Teflon Ron. Can you say Teflon Ron?
Teflon Ron. Okay, good.
okay, on the other subject, Ron, could you talk about?
Notice I didn't answer a question. Notice I did not answer a question.
It was good. It was good. I liked it.
No, but I've never been in jail. I got indicted once, but I beat that.
Hey, that Teflon is cancerous, don't be around it.
So the question I want to ask now has to do with the sound money aspect of much of what we've talked about today has to do with the fake IOUs, the promissory notes, the current debt-based system. What is your view of the importance of the gold and silver coin aspect, and is it ever going to ever be a reality again, or do you have no focus on that whatsoever?
Oh, yes. Oh, yes.
Well, the solution to our money problems is the institution of the public credit money system. Okay, one of the emails I sent Ken, which he's going to forward to everybody, is a discussion of the monetary reset and the institution of the public credit money system. And the way the public credit money system works is instead of giving the banker cabal, which is private bankers, control of the money in the country, the U.S. Treasury would issue the credit at maybe 10 or 20 basis points, not even 1%, maybe 10 or 15% of one interest percentage, 10 or 15 basis points to cover the administrative charge of administering the credit. So in other words, they would make loans available to people to buy, to borrow via credit of, instead of paying interest of 7, 8, 9, 10%, it'd be 10 or 20 basis points. 1/10 or 1/20th or 1/5 of one interest percentage. So that would reduce the cost of borrowing tremendously. So everyone would be able to buy their own home and live the American dream of having their own home in America. Isn't that what America is all about? You have your own home, your own yard. It's the institution of the public credit money system. If you were to do that, people could borrow money, credit, and form businesses. And businesses need employees. And employees need salaries and wages. So it would be a boom to the economy to start small to medium-sized businesses with credit financing from the U.S. Treasury and not going to the international banking cartel at 10%. You follow me?
I wondered how they were going to do it. That's great.
Just think about it. Iceland did that. Iceland is a booming economy. They threw the bankers out, the Rothschild bankers, and that's how they're running their economy, by having their treasury issue the credit at little to any interest. So if you can do that, you don't need the IRS. You don't need tax on salaries and wages. Imagine keeping all the money you earn from your labor with salaries and wages and not paying any tax. It's like immediate 30 to 40% increase in your wealth. And you take that money, you invest it in your home, you buy a home, you take care of your family, you send your kids to colleges, and college would be free if you wanted to go, or the trade schools.
Yes.
We more carpenters, plumbers, roofers, electricians, accountants. We don't need any more lawyers. We'll get rid of them. And you don't have to pay any tax. So instead of taking the tax out of the hands of the British Royal Crown Bank Corporation and their gangbangster cabal, you put it back into the hands of the Americans. 70% of the economy is driven by American spending. So if you take that extra 30 or 40% in tax and interest, give it back to the Americans, what's going to happen to the economy? It's going to explode. You'll have a revitalization of this country like you've never seen before. People will start small businesses. People will go to college. People will go to trade school. They'll have enough money to buy food, pay the utilities, no more real estate taxes, no more income tax, and that's the way it was supposed to be. That's the way the founders envisioned America.
And
If we did that, people from the rest of the world would flock to this country because of that opportunity.
and good.
Public credit money system.
Mhm. So when do you see this happening?
Well, we've got the deep state is that the banks control the politicians.
Mm-hmm.
Their campaigns their campaigns are funded by the banks. Because you'll notice Goldman Sachs gives the same amount of money to Obama as he did to John, what was the guy he ran against? The Air Force guy, the prisoner of war.
McCain?
McCain. Goldman Sachs gave as much money to Obama as he did to McCain because whoever got in, they're going to be on his good side.
Right.
So the money controls the politicians, and the politicians, kowtow to the corporations and the banks. So they've got basically a lock on the system. So we got to eliminate campaign contributions to politicians, and they got to be representatives of the people, not the corporations and the banks.
Mm-hmm.
So we got to dissolve the Federal Reserve Act of 1913 and put the power of money back in the hands of where it belongs, the people, not the corporations and the banks. And if we did that, continuous wars would stop. Continuous wars would stop because the politicians are sending trillions of dollars to Israel and Ukraine right now. And whose pockets is that money ending up in? The Ukrainians or the Israeli on the street? I don't think so. And certainly not the Palestinians. It's ending up in the pockets of the CEOs of the military industrial complex and the politicians. By institution of the public credit money system, that would all come to an end, a grinding halt.
Hey, Ron, I'm Ken.
But
I have a question for you.
Yeah.
How can your forensic accounting services help with a criminal case?
Say that again, Ken.
How can your forensic accounting services help with a criminal case?
What kind of criminal case is it?
One where it's a state against an individual. I guess I was wondering, trace the bonds and the profits they're making off the bonds.
I can't hear you. I've only got 60% hearing in this ear.
Okay. Yeah, I was wondering if you can, how your criminal or your forensic accounting services can help in a criminal case. For example, possibly tracing the bonds and showing the profits they're making off the bonds.
Yeah, well, we know they're making. It's the court. It's the CRIS system, court something investment system. We know they're selling the court cases, the account receivable to Wall Street, and they're bundling those together and selling those as asset-backed securities to the investors, the investing community. We know that for a fact. Are you going to get your hands on that? I don't think so. So I guess I don't know how to answer your question. I do these forensic property and mortgage loan audit reports, but that's basically to show that the plaintiff doesn't exist. There's been a break in a chain of title of the assignments on the mortgage, and the accounting has been there's been hoodwinking and phony accounting going on. And so when I show that there are breaks in the chain of title, then we can make the case that, hey, the person coming after the house in foreclosure doesn't have proper standing and proper ownership here of the title. And that's how we operate there. But in terms of a criminal case, I'm not sure how I can help you there, to be honest with you.
Yeah, thank you.
What happens to property that, say, this woman who got the house free and clear? Two questions. Is she still being sent property tax bills? And then the second question is, what happens when that type of property goes into probate or is willed to someone else? Does the fraudulent government come back in and reattach the property and go through the same whole process over?
is that kind of property assessment value that is the issue there, or? I don't
No,
understand.
my question is, you said the woman got her house free and clear recently. So is the property tax, is it still on the tax rolls? If she got it.
Yeah,
free
I
and
mean, that's
clear?
gonna be an issue for the lady. That's gonna be an issue for the lady. Because, she has to continue to, uh, pay those property taxes. And if she goes into arrears, I mean, they can have put a lien on the house and then sell the lien to someone who would try to foreclose on her again. So, the best, if she's destitute, obviously she's going to fall behind on the property taxes and the homeowner's insurance, right? So, her best course of action might be to sell the home, take a profit, and then, downsize or something like that. Move into a domicile that's more sustainable from an income perspective.
Basically, because anyone who has the power to tax has the power to destroy, correct?
Yeah, I mean, that's what this reset is all about. They have the power to tax. They have the power to charge a high exorbitant interest rate on a loan and then charge high homeowners property insurance. And then, through their relationships with the food companies and the pharmaceuticals, increase the cost of food and medicines. So you can see the power that these demons have. That's all going to change.
So, Kim Clement, who is God's prophet, he's talking about that the economy is going to fall in the fall. Of course, we don't know which fall that is, but I certainly would hope that it would be this fall. Of course, we hoped it was last fall and the fall before that too. With your having a perspective on the economy, are you seeing anything?
Well, I know the banks are going to have quantitative easing again. They're printing money like there's no tomorrow.
Okay.
It's going to cause more inflation, higher cost of living, higher real estate values, higher tax assessments, higher insurance costs, higher food costs, higher gasoline costs. At some point, that system's got to break.
Well,
It's just unsustainable.
if
And at the same time, companies are closing, companies are laying off people and going out of business, which means people are being jobless, and then, they're defaulting on their mortgages. So it's a downward spiral. I mean, this is an orchestrated plan by the British city of London to destroy the United States.
right.
I mean, Britain, the city of London, is trying everything they can do to entice Trump to go into a war with Iran and Russia and Ukraine.
That's so crazy because Trump already has the goods on. Putin and Trump are working together. She and Trump are working together already.
You see, Trump's take is, look, I don't want to go to war with these people. I want to do business with them because, Russia's got 200 million people. China's got 1.5 billion people, and India has the same amount. Let's do business with them and make money instead of go to war with them.
Yep.
See, the British Empire model is continuous wars.
Mm-hmm.
And put one party against the other. Put the Jews against the Muslims. Go into the United States and put the patriots against the liberals.
Mm-hmm.
They did the same thing in 1861 when they foisted a civil war on the South and the North. Britain is very good at putting one group against another, creating a war, a civil war, and then they sell arms to both sides. That's the British model.
Hey, Ron, we got another guy that's got a question here, and then I think we need to wrap it up.
Okay.
Hey, Ron, this is Jeremiah, your buddy here.
Hey, Jeremiah, how are you doing?
Hey, doing good. Thank you for asking. How are you? So one, I don't think we ever got to, we were gonna talk about possibly, what to do before you go into foreclosure, before, we need to be proactive. We
Yeah.
never really hit on like the proactive part. Can you kind of summarize that up and who to proactively send the debt validations letter to for your mortgage?
Yeah,
And
you want to send the debt validation letter to the servicer and the alleged holder of the note. Like in my case, the holder of the notes changed several times. It's now Metropolitan Life Insurance Company in New Jersey, and the servicer is Select Portfolio Servicing Inc. out in Salt Lake City, Utah. But it's changed several times since 2016. So whoever is sending you the monthly mortgage statement, that's who you want to send the series of 4 debt validation letters. And you want to
Okay.
send one out every 30 days. And at the end of the 30-day period, you send the second one out. And then at the end of the 60 days, you send the third one out. And at the end of the 90 days, you send the fourth one out. And if they haven't responded with the information that you requested, you send them a default notice. Then you take that paperwork and go into your local court and request a declaratory judgment. Okay? Because that's your discovery package. And you can actually get a judgment against them coming right out of the box. It'll take anywhere from 90 to 120 days to do that process, but you can do that.
Okay. And
So
are you
that's
gonna
being
be,
proactive. That's being proactive.
and I have some notes I need to go through. Are you gonna be speaking again tonight on Tuesday night?
Yes, I am. At 7:30 New York City time. I think that would be 6:30 Central time, which you folks are Central time, I believe. On the Telegram channel, 7:30 or 6:30 your time tonight.
All right, Ron, thank you for everything you do.
You'll be
Yeah.
on, which Telegram platform will you be on?
We are the law discussion group. We are the law discussion group.
Thank you.
Okay,
At 7:30,
anybody
you'll
else?
see join the discussion. You'll see it up above in the taskbar.
Great. Thank you. Thank you so much.
Yeah, if Ken could forward those emails I sent him, I think there were 3 emails. If you send it, distribute it to all the folks, you'll have the information you need. And you can call me 24/7. My number is 508-878-8390. That's 508-878-8390. That's my mobile. I'm available 24/7. This is what I do. This is what I love. I love helping my brothers and sisters. And there's nothing that makes me happier than to stave off of foreclosure. The other thing is you can get me on email at ron, ron.adams, one D in Adams, 12, ron.adams12 at outlook.com. And I usually respond to my emails every day.
Okay, Ron, I think we need to wrap it up here. I think people are ready
Hey,
to go home.
Randy,
Yes, sir.
you got to stop being so shy and,
I know.
being a man of a few words. You follow me? Baby,
I know.
Randy, baby.
Yeah, Ronnie, baby. All right. So anyway,
You can tell I hate this guy. You can tell I hate this guy.
Anyway, so I'll see you tonight on Telegram, and thank you for doing this. I appreciate you being here.
Yeah, you look good, man. You look like you rallied from your condition there.
What was that?
You look like you rallied from your condition a couple weeks back.
Yeah, I bounced back. I feel a lot better now.
Good. All right.
And now
Thank you, everybody. And happy trails from Texas. Remember the Alamo, March 6th, 1936.
Right.